Hi, everybody. Welcome to Trial Alchemy. And I have as my guest today retired Judge Jeffrey Barton. Let me tell you a little bit about Judge Barton. He started practicing law in 1981 in San Diego, and he was an accomplished civil trial lawyer for many years. He was a partner at Lewis D'Amato, Brisbane, Biscard, and he joined ABOTA in 1995, and then Judge Barton was appointed to the Superior Court bench in 2001. But he served throughout his time on the career bench from 2001 to 2021. He was 12 years in the Civil Independent Calendar Department, but he also had many other assignments, including family, criminal, open trial department in all kinds of cases. He was the assistant presiding judge for 4 years, from 2014 and 2015. Then he was assistant presiding judge for 2 years, and he was presiding judge of the San Diego Superior Court for 2 years in 2016 and 2017. So without any further ado, Judge, let me just welcome you to Trial Alchemy. Thank you for joining us today.
Well, thank you, Monty.
Now, most of the discussions on Trial Alchemy are talking about the trial of cases, and we're going to get there. But I want to start a little bit before the trial, considering your experience. So let's start first with an area that all lawyers, even if they haven't tried many cases or any, start with, and that's law in motion. And do you have any, from your years of serving on the bench and being an independent calendar judge in the Superior Court, do you have any tips or suggestions that you would make that would help lawyers do the best they can do in the law in motion arena?
Yeah, I have several ideas based on what I did every Friday for 12 years. I think one of the most important things is first making the decision whether you need to go to law in motion, and making sure that what you're doing moves the case forward. There are a lot of times when law in motion seems to be an end in and of itself. So, for example, on discovery matters, oftentimes the only meeting and conferring that's occurred before the filing of the motion is sending emails back and forth, basically threatening the other side with everything that they're doing wrong, as opposed to truly meeting and truly conferring, either in person or by telephone, and with the people involved in the case who have the power to make decisions. So I think screening to begin with is very important. Another aspect to that is demurs. And I know you and I were trained similarly in regard to demurs, and it can be a useful weapon, but you need to use it under circumstances where you can actually accomplish something and have a true shot at knocking out a significant cause of action that will affect the complexion of the case. Saw many times what I call the defense quest for the perfect complaint, where you'd have a super specialist defense lawyer, plaintiff's lawyer who perhaps wasn't as fluent in the current state of the case law. The defense lawyer then would point out all the defects in the complaint, point out all the cases that supported those defects, and educate the plaintiff's lawyer to the current state of the law. When you're actually filing your motion, it's amazing how many motions start with like a procedural history of the case or sort of boilerplate citations about the power of the court to grant a motion for summary judgment, for example, which is all stuff we already know. I mean, you might have to throw it in there, but you need to start your motion with something that attracts the judge's attention, and to indicate in the first 2 paragraphs, maybe 3 paragraphs, what it is you're seeking and why you're entitled to it, and try to do that in an interesting way, rather than starting with the complaint was filed on July 1st, the answer was filed on, August 15th. And many motions start that way. And as someone who's reading 18 motions for every Friday, it's just not the best way to get your judge's attention.
Well, let's go over these a little bit more. I think they're all great suggestions. So let's say first about meeting and conferring. What I've noticed when I've been involved in dealing with discovery issues, typically in my situation as a referee, so you did it every week as a trial judge, but if you only send a text or if you only send an email, what I've seen is people don't tend to really meet and confer, and they don't tend to communicate. They just kind of harden their positions. Do you think it's better to talk on the phone or talk in person? I think that's at least in person if you can, but if you can't, at least on the phone, and try to really communicate. What do you suggest about that?
Absolutely. I mean, a lot of times the emails that go back and forth are really just sort of rough drafts of the motion they're going to file.
Yep.
And there's really no meeting and no conferring that's going on. It's stating positions and threatening sanctions. And that usually gets the other side's back up. And I think proof of the fact that actually meeting and actually conferring, and that means at a minimum on the phone, hopefully next would be by Zoom and best in person,
Yeah.
is the fact that so many issues resolve out in the hallway while waiting for the motion to be heard, or more importantly, or more realistically, on ex partes when counsel are waiting to get called up to get their order shortening time to get their motion heard. And because that's the first time that they've actually sat down eye to eye and had to compromise, and in fact did, and realized that their opponent's, a nice person and not someone who's just threatening to sanction them $50,000.
Well, you and I did have similar training. We were lucky to get trained by great lawyers at the McGinnis Fitzgerald firm in the early 80s. But in terms of being an effective trial lawyer, whether you're in the trial court trying a case in front of a jury, or you're in front of a judge or working your case through, it's really important to be thinking strategically about that case from the very beginning. What is the goal? What's the best result you can get for your client? How do you get there? And if you're thinking strategically, you get to one of the points you just mentioned at the beginning is, well, do you really need to file a motion on a discovery issue? Is there some way you can resolve things and get something that you really need, but not fight over stuff that's not going to be that important? So, I mean, there's a lot of motions that are probably filed as discovery motions. I'll bet you saw a lot of them that maybe you don't even need to file.
True, and I think the root of that is something that I'm sure you see as a referee, which is over-inclusive discovery requests that just lead to problems. And it's almost as if lawyers are sometimes reacting in a step-by-step process. In other words, okay, it's discovery. I've got to get every single document that the other side has, for 10 years preceding whatever is relevant in the case, and not sitting back and thinking about trial and what it is they're going to use and what they actually need, and perhaps tailoring their discovery accordingly. I was trained by a lawyer who had 3 interrogatories that went out on a case, and then later when I was farther along in my career, I grew that to 7. And really, discovery is useful to identify documents, people, and contentions.
Yep.
And anything past that, it's really not that effective.